Good morning. This is Attorney Vince Davis, and these are the office hours. Today, we're going to talk about appeals and writs in a CPS case. We've talked about the detention hearing, the jurisdictional and dispositional hearing, the 6-month review hearing, and the 2-6 hearings, and the 388s in the past shows. Today, we're going to talk about the appeals and the writs. Now, in California, there are a couple of different types of writs, and there's one appeal. An appeal can be taken as a matter of right to a higher court, and those can be filed after the disposition hearing, after every 6-month review hearing, and after your rights are terminated, if they're terminated, and also after a 388 has been denied, if your 388 has been denied. Those are the only times you can file an appeal. Now, at the hearing where your reunification services, if they're terminated, you used to be able to file an appeal. Now you have to file a writ. Generally, writs are discretionary for the Court of Appeal to take and decide. For example, if you take a writ after the jurisdictional hearing, if you lose it, the Court of Appeal doesn't have to decide or make a decision on that issue until the disposition hearing. But a writ after your rights have been, or your family unification services have been terminated, it is a mandatory writ that the court must accept and make a decision on. And back many years ago, it used to be an appeal, but they changed it to a writ. And someone was explaining to me many years ago that this was done, they thought, to change the funding requirements. If you file an appeal and you're indigent, the Court of Appeals, through their budget, funds your court-appointed attorney. But if it's a writ, the way they made it a writ, the Court of Appeals doesn't fund your writ or / appeal. Your trial attorney has the responsibility of filing and representing you in that writ. So you're a trial attorney, and the superior court, the trial court, have the problem or the issue for the funding. You see, it was just a matter of economics, as most things are in our country. So that was the explanation given to me. Makes sense now when you think about it, because you still get to have a mandatory writ where they still have to make a decision, but they're calling it a writ and not really an appeal. So let's talk about an appeal first. When you file an appeal, you have to file something called the Notice of Appeal. And in California, and it may be different for a lot of states, but in California, you must file this Notice of Appeal within 60 days of the judgment or the order that you're appealing from. Okay. A lot of people, unfortunately, sometimes miss that 60-day period. So the best practices, in my opinion, are if the judge makes a decision that's appealable and that you don't like, you should file your Notice of Appeal that day. In California, if you can't afford an appellate attorney, generally the Court of Appeals will appoint you an attorney. And they do that through an organization called the California Appellate Project. Well, that's what it's called here in the 2nd District in Los Angeles. And it goes by similar names in the different districts around California. But you get a court-appointed appellate attorney if you can't afford a private attorney. Now, one of the things that the Court of Appeals, at least in the 2nd District, does is they make you qualify. You actually have to, I think, answer some questionnaires about your financial status, your income, and that type of thing, because, sometimes people that can, quote unquote, qualify don't qualify economically, and they are required to get their own attorney or to pay for the appellate attorney. Anyway, so you file the Notice of Appeal within 60 days of the order which you're appealing from. And remember, not every order can be appealed. But let's say that it's one of those orders that I mentioned earlier that can be appealed. Once you file that notice of appeal, it starts process running. And that process is that the trial court and its clerk must prepare the record on appeal. Now, the record on appeal is defined as the transcripts of all the hearings, which were part of the appellate or the order that you're filing an appeal on, and the clerk's transcript, which is all of the documents that were filed or produced in the trial court. For example, the minute orders, the social worker reports, psychological evaluations, the drug tests, anything introduced into evidence or even not introduced into evidence, but that's part of the clerk's transcript. So all the pieces of paper become part of the clerk's transcript. Now, one of the important things that you want to do is when you get the transcripts and they're prepared and sent to your appellate attorney, you and your appellate attorney must make sure that the record on appeal is complete. Sometimes the clerk leaves out something that's very important. Let me give you an example. This happened many years ago. One day I got a call from a colleague who said, "Congratulations, blah, 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 you won that so and so appeal." And I didn't know what he was talking about because I hadn't been notified or I didn't know that I won this appeal. But in that appeal I won, the when I got the record on appeal initially, it was missing some things that I thought were important to the appeal. And at the time, I was doing it as a court-appointed appellate attorney. I don't do court-appointed appeals anymore. And I made a motion to augment the record, in other words, to add on to the record. And I got a call from the person who supervises the court-appointed attorneys from the Court of Appeal. And this person told me, "Oh, you don't need that. I don't think you need that, blah, blah, blah." And, me being the young, feisty attorney I was, I said, "Well, basically, I don't care what you think. I'm the attorney. I'm appointed to the case, and I think I need that." By the way, I was the trial attorney, so I know, I think better than you what I need. Now, that was a very bold statement and position for me to take. As I found out later, this attorney was far more experienced than I was in appeals. But I just happened to be right because when I did win the appeal, the court relied upon the documents that I asked to be added to the record. And after I won the appeal, I got a letter from this person who didn't want me to add that to the appellate record, just telling me congratulations. And I, didn't say anything. I wanted to say, well, I was right, but I had already realized that she was much more experienced, and I just got lucky, right? Sometimes luck plays a part in what you're doing in life, and in this particular case, I got lucky and I won that case. I think that case was actually ended up being a published decision, being part of the law in California. So if you Google my name for appellate decisions, that will be one of the cases that comes up. So you got to make sure your record on appeal is complete. Once the record on appeal is complete, you and your attorney as the appellant have, I think it's 30 days to file your brief, your appellant's opening brief. Once that is filed, the respondent, the county usually, and maybe the minor's attorney, has 30 days to file their brief. Inevitably, the county asks for extensions. Even appellants ask for extensions sometimes. And the court, if there's good cause, grants you an extension of 2 weeks, 2 months, 1 month, whatever is asked for you to get an extension. But once that respondent's opening brief is filed, then you file, as the appellant, if necessary, you file the appellant's reply brief. Now, this is a brief that you reply to the county's or the minor's attorney a response to their brief. So it's appellant's brief, respondent's brief, and then appellant's reply brief. Once all those briefs have been submitted, and by the way, you don't have to file a reply brief. A lot of people think it's good practice. Some people think that you don't want to do that unless it's absolutely necessary. So it's called the practice of law. So once all of those briefs have been submitted, then the court takes it under review, and eventually the court will set a date for oral argument if oral argument is requested or needed. In a lot of cases, oral argument is not needed, and sometimes strategically you may not want oral argument. And then once all of that is complete, then the court issues a written decision. The written decision can be what's called a published decision, which actually becomes the law of California, or it can be an unpublished decision, which means it's just the law of that case. Okay. So I've done, quite a few appeals over my career. Most of them are unpublished, but I have a few published decisions as well. So that's the appellate process. Let's talk about writs. Now, I told you earlier that there are different types of writs, WRITS. There are writs of mandate, writs of certiorari, writs of prohibition. So when you file a writ regarding a trial court decision, you want to make sure that you and your attorney are filing the right type of writ, right? So sometimes if you file the wrong type of writ, that'll be grounds for the writ being denied. Generally, writs are decided quickly, and sometimes it's just a one word granted or a one word denied. And that may happen in the first 1 or 2 weeks. And there's not always a decision issued, or there's not always a call for the other side to even file a response to your writ. But the important type of writ is the writ that you want to file after your family reunification services have been terminated. Now, here's the little trick. And I see attorneys, even people who say they're experienced attorneys, this is the mistake that they make. When your family reunification services are terminated, the mistake I see a lot is that the attorney will file a notice of appeal. Well, that was the rule 15 or 20 years ago. And if you file a notice of appeal when your family reunification services were terminated, your appeal will be thrown out and you won't get to quote unquote appeal that decision. Okay. I just saw that happen on a case. A client came to me, his family reunification services were terminated, and his attorneys filed a notice of appeal. Now, presumably, this particular attorney is an experienced attorney in juvenile dependency, or so I had been led to believe. But he and his office filed a notice of appeal. And because of that, the appeal was dismissed or thrown out because it was the wrong type of appellate vehicle. And the guy never got to appeal or have reviewed the termination of his family reunification services. And to be honest, based upon the story that he told me, he had the classic case of probably getting a reversal of the termination of his family reunification services. Subsequently, he went on to have a 2-6 hearing, and he lost the 2-6 hearing. So as of right now, and I think he's appealing that, as of right now, his parental rights have been terminated. But a lot of this probably could have been avoided had his attorney filed the right document when he lost his family reunification services. You don't file a notice of appeal, you file what's called a notice of intent to file a writ. That's a whole nother form. So in the Court of Appeals, or in the trial court, if you file the wrong form, you're out. Okay, there's no going back. So if an attorney tells you they're experienced and they don't know that rule, they're not experienced. Once you file the notice of intent, and I think the notice of intent has to be filed within like 7 days of the day your family reunification services were terminated. So it's a very short window. You got to file that notice of intent. Once you file that notice of intent, the process looks similar to to a regular appeal. The record is prepared. You file your appellant's opening brief on the writ. The county files their responding brief. You file your reply brief. You have oral argument if necessary, and then the court makes a decision. And because, there's the selection and implementation hearing, the 2-6 hearing that's coming up within the 120 days, the court makes these decisions quickly. They're on a high priority timeline. So you don't wait, the months and months like for a regular appeal. So make sure that you talk to your attorney that if you want to appeal, quote unquote, the termination of your family unification services, you don't file a notice of appeal. You file a notice of intent to file a writ. Big difference, simple mistake, see it all the time. Now, in some cases, at the disposition hearing early on in the case, the court makes a decision not to give you family reunification services. Okay, and sets the case for a 2-6 hearing. When that happens, you don't file a notice of appeal, you file a notice of intent to file a writ. Now, I was talking to an attorney recently who told me, a very experienced attorney, who told me he files both. And, sometimes the notice of appeal is just dismissed, and sometimes they combine it. At least that's what he told me. But you want to make sure that you are filing the right piece of paper, because if you file the wrong piece of paper, there could be no recovery for you and you lose your rights, eventually lose your parental rights, as this client or prospective client who I told you about, what happened to him. And his case was, I think, down in Orange County. Okay. So that's the difference between an appeal and a writ. And if you have any questions or doubts about what's going on, you must talk to your attorney. And if you have any other questions or want a second opinion, give me a call at 888-888-6582. That's the number that appears on the screen. All right. Let's see if we have any questions here. Leica, who's watching on YouTube, says, Uncle Davis, you must help me. Something is going on. I did phone yesterday and I was informed I will be called by you. Don't forget. Leica, you better call 888-888-6582 and make sure that you're on the calendar today. Leica says, I feel she is slipping through my fingers. I can't let this happen. She and me are innocent. Leica, call me or text me at 310-308-7758, and I'll definitely get in touch with you today. Christina Reynoso, watching on Facebook, says, do you not see my question? Thank you. 60 days. I believe I was told 30, and I was late. I'm wondering if I'm wrong. My court-appointed appeal attorney office was across from the court. Anyways, I filed an appeal on my own. I have a question from yesterday. My regular attorney was working with judges laughing. My appeal attorney's wife worked in the small offices, health department, same office as CPS. Okay, Christina, I'm not sure what you're trying to ask me there, young lady, but if you want to talk about it further, call the number on the screen, 888-888-6582, and I can talk to you today. I probably have some time today to talk to folks. I found out yesterday I don't have to go to court today, so I'll be working from home and in the office working today, and I should be able to take some calls. All right, Nye Peace, watching on YouTube, says, Hold on, I lost it. Hold on, YP. I'm trying to pull up your question again. I can't pull you up in YP. I don't know why. Oh, there it says, can judge close case but still order reunification services in order to get my children back even after I won? I'm NIP, I don't understand that question. The judge can't close the case. Well, if the judge closes the case, there's no more family reunification services, period. The case is over. Family reunification services is only given while the case is open. Okay, so I hope that answers your question. Hold on a second. Little Nugget says, watching on YouTube, good morning, Mr. Davis. It's Sabrina G from San Diego, Palma Reservation. Okay, so you're on an Indian reservation. I'm just getting the info together and got to get you paid this weekend because they continued jurisdiction and disposition for Monday. Oh, okay. Little Nugget, well, when you're ready, give me a call. NIP says, I figured that. NIP says, corrupt. I want to mention something to you guys. I get a lot of complaints about the system being corrupt. And in a lot of cases, I can see why people are saying that. But I want to tell you guys something. In a lot of cases, it's not corruption. It is you not knowing what the rules are. And however that may be unfair, there's that old premise that was taught to me in law school: ignorance of the law is no excuse. So your complaints may be more about the system than about the implementation of the system. There's that example that I give all the time about a man who went to court to change custody representing himself. And he had the medical records and the school records to show that mom was doing a bad job taking care of the child. And when he got to court, he showed the judge the medical records and the school records. And the judge says, well, I'm not going to consider those. And he ruled against the father, and they left the court. And the father just complained and complained and complained that the judge was corrupt. And I explained to the gentleman, I said, well, the judge wasn't corrupt. It's just that you didn't know the rule. And he said, what rule? I said, well, you just can't show up with documents to court and expect the judge to accept those into evidence. And he said, but those really were the documents. And I said, I have no doubt of that. I said, but that's not what the law says. The law says that if you're going to bring documents into court, there are certain steps you have to follow to get them into evidence so that the judge will consider them. And the guy says to me, well, that's just stupid. And I said, well, you may think that it's stupid, but that's the law. And I said, based upon what you've told me, the judge made the right decision. He says, but that's unfair. I didn't know. And I hear that a lot. That's unfair. I didn't know. And like I learned in law school, which I found very difficult to accept, one of the main premises of our English common law system is ignorance of the law is no excuse. So if you accept that that is the rule, maybe it shouldn't be, but that's the rule. If you don't know, that's your fault, unfortunately. So it always pays to talk to a lawyer, get some advice. I got a message from someone late last night who I gave some consultation to, and he told me that he wanted to represent himself in a CPS case at the time of the jurisdictional and dispositional hearing. Very smart guy, has a good job, college graduate, very smart guy. But the judge refused to allow him to represent himself, which I think is the right decision because even though this guy is smart, he doesn't really know the law. He doesn't know the rules of evidence. He doesn't know the rules of procedure. it would be suicide for him to try to represent himself. He's insisting that he not be represented by a court appointed attorney. Okay, I understand that. But if he's going to do that, if he can't, if he doesn't want to take a court appointed assistant attorney and he can't represent himself, what's the only alternative? He's got to go out and hire an attorney. All right. So those are the rules. Let's not try to change the rules unless you're going to get out there and change the law by voting or organizing people to vote. Which, I talk to people all the time and folks tell me, oh, this is unfair. We should change the laws. Okay, I agree. What are you going to do about it? You going to organize a million people to, have them vote and change the law or change the elected official or vote out a judge? Because if you're not going to do that, you complaining is a waste of time. I on a lot of telephone calls, people start venting to me, and I let them go on for about 10 or 15 minutes. But at some point, I tell them, look, you know what? I know how you feel. I understand, but that's not going to win your case. Okay. Complaining about it is not going to win. Let's win the case. And if you're really serious about your complaints, let's sue them afterwards for violation of your civil rights. That's the bottom line. Okay, Lika says, can I hire Attorney Davis? I'm from South Africa. Well, Lika, if you're in South Africa, Attorney Davis can't go to South Africa to do your case. But if you're from South Africa and you're here in the United States, especially in California, I can represent you. Watching from YouTube Child says, I hurt with you, dear Lika. I pray our Savior strengthens your heart with his loving power, for your daughter needs you, Mama, in the name of Yahweh. Amen. Okay. All right, folks. We've come to the end of these office hours. I hope to see you guys tomorrow at 6:30 a.m. Pacific time for office hours. Please write down your questions today or tonight so that tomorrow you can just post your questions and hopefully I can get to them. Okay? All right. Everyone have a good day. And we'll see you tomorrow.